Good afternoon, everyone. I'm Anthony Ross, immediate past president of the Beverly Hills Bar Association. Welcome to part 2 of best practices for effective depositions. Part 1 was a very basic nuts and bolts of depositions. If you have not seen part 1 and you're interested, you should definitely look at it. Today, though, we'll talk about leveraging depositions through objections, motions for summary judgment, and trial. And I'm joined by Daniel Kramer and Rachael C. Kogen.
Hi, everyone. Thanks for tuning in for part 2. We're really excited to show you how, the depositions, the discovery phase really plays into crucial moments in the case, meaning an MSJ for the defense to try to get the case kicked out, or how it all comes together at trial. So I think it's very important that, as attorneys of all ages, of all experience, they understand how it all plays together, why some maybe innocuous objection that you feel like in a run-of-the-mill deposition can actually play a crucial role in how it all comes together in front of a jury one day or a judge who may throw out the case. So we're really excited for this session, and we'll go ahead and get started. I'm going to share my screen real quick. All right, so we left off last time kind of talking about objections and how you object in deposition. We did a pretty thorough explanation of that. But now we want to talk about some strategy, and I'm going to kick it to Rachael to start us off on what do you do when you have an evasive witness. So Rachael, you got a plaintiff who's just not really giving you what you want, but they know it, and they're being evasive. So how do you really pull it out of them like a detective interrogating a criminal?
Well, thanks a lot, Dan, and hi, everybody. Thanks for being with us. I think the key is really not to back down. And if you think that the witness has an answer that you need and they're purposely being evasive, you just got to ask nicely, not in an aggressive way. We're all trying to be civil, but come at it from a few different directions. If you get a lot of I don't knows and I don't recalls, you can follow up with, where would you go to find this information? What have you heard about this matter? Who might know where to find the information? What records exist that might contain the information? Did you once know the answer to the question? And what might bring back your memory regarding this matter? You can also use records to refresh their recollection. If you have some information that you think, well, this witness is hiding information, it can actually be helpful to get a few I don't knows and then put the record in front of them and show them that, well, maybe you actually do know, and here's some proof that you do. So what do you say about this? And as a defense attorney, you can really discredit a witness after you get a few I don't knows. But I would keep at it, especially if it's information that's critical to making out your case or to the defense. This is your one chance with this witness, so don't back down.
Yeah, and I have two schools of thought. So, discovery depositions, I should say, they serve two purposes. One is obviously to discover information, to gather information that you need and all that. Another thing, especially me, if you're a trial lawyer and you think the case may go to trial, or your partner's a trial lawyer, or whoever's going to handle it at trial, sometimes I don't knows can be your best friend. And the witness may think they're being smart and clever and just, be like, oh, we're going to get away with it because I'm just saying I don't know, or pleading the fifth, whatever. I use that and I love it. I'll get so many I don't knows in a row and just like all these things that they should know the answer to. And then I'll just just machine gun them with all these questions, very basic questions. They're going to keep going. I don't know. I don't know. I don't know. And then I'll hit them with that in my opening statement, as I'll show you later how you play the deposition and opening statement. And then you have, for example, from the plaintiff side, a PMK, or a person most knowledgeable for a corporation, doesn't know anything about, if it's a PI case, the safety rules at all in their store or for their company. And they just say, I don't know, I don't know, I don't know. But yet they were designated as the person most knowledgeable by the corporation. That is solid gold to me. It means they don't really care, or they're not the right person, but they couldn't find the right person. So sometimes I don't knows can be a sword to be used to just show, the ostrich sticking their head in the ground, which is a common theme we like to use if we're going against corporations.
Yeah.
But Rachel's 100% correct in that if you're really trying to push for the information, they have it. I like to do a lot of, in our admonitions, we always talk about, give us your best estimate, just don't guess. And we give them examples, all sorts of common examples of what's the difference between a guess and an estimate. And then if they're not giving me, if they're saying, I don't know, I will go to extreme. I'll spend, 10 minutes or 3 full pages just going, okay, well, was it between, a day or a month ago, or a day and a year ago, or 10 years ago, or if it's distances, was it 1 feet to 5 feet? 1 feet to 1,000 feet. Just make the most extreme, and they can't even give you an estimate within that. Then they just sound absurd to the jury. And if their attorney knows what they're doing, or if it was me defending a deposition where Rachel's going down this path, and I know my client's going to look foolish if they're being evasive, then I will just be like, just answer the question. It's not going to help you being evasive. Juries see right through it. So you definitely got to hammer on. Don't let some attorney on the other side object and say, ask and answered, because that's a bullshit objection, frankly. And most 99.9% of the time they haven't answered. Clearly, that's why you keep asking it. And a lot of times you have changed the form of the question. So it's an improper objection. Don't let the attorneys bully you around. Get the information you need, because depositions are all about boxing people in for trial. You don't want to give them an out at trial. So you got to block them in, and all these questions Rachel put together here are exactly how you do it. You make sure you turn over every stone of who has the information, who could find the information. You tell me every single person, where they were at the time, what they were doing, which direction were they looking, who were they with, how far away were they from this person, when you're trying to get information on a conversation. So don't ever give up to try to find the answer. Tony, what do you think?
Agree with that. Yeah, I agree with that. What I would do also is I also make sure, pardon me, I make sure that I can get a clear record. Sometimes you get enough I don't knows that your record is not clear. You're trying to get an answer to your question that's close in time to your question, so that your question was the light red or red or green. If there's enough colloquy in the middle, they finally say it was green. That's not what you want. You want to make sure that you go back and say, okay, so we've established that your testimony is that the light is green, right? So just kind of condense it so that you get what you need out of it in a little bit of a soundbite, as opposed to, with all the objections and all the confusion that happens sometimes with these questions.
Yeah, Tony, that's a very good point. Can't stress that enough, because when you're in trial and you think you got good impeachment for the witness, and then you realize you never actually asked the conclusory question, like Tony's talking about, after 10 pages of going back and forth, then it's really hard to impeach and have that dramatic effect in front of a jury, because you got, you're like, the question's way up here. You got to go 3 more pages and read all this. Judges don't like it. You waste the jury's time. So you always want to condense and finalize it in just one simple question and get rid of all that 10 pages of colloquy, like you said.
Yeah. The one other thing I would add, Dan, which is a very good point that you made, since you're going to be using those I don't knows on behalf of the plaintiff at the time of trial, as a defense attorney, and I guess even as a plaintiff's attorney, you want to make sure your witnesses are well prepared for having the information and testifying about the information that they should know about at the time of trial. So like I've had that happen where there's a nurse who's signed off on a hospital policy, and she'll, when I prepare her, she's, well, I don't remember this policy. I don't know what it's about. And I'm like, you better know for the time of the deposition for this exact reason that you signed it, you should know about it, and let's figure out what you knew at the time you signed it so you can testify and sound intelligent. So the I don't knows absolutely can be used against a witness, but the flip side of that is we have to prepare the witnesses that we're representing to make sure that, they don't say I don't know when they really should know.
Yeah, that's so true. It works both ways. I hate it when my clients say I don't know. It's like, just give an estimate, even if it's wide ranging. Try to show you're trying, to give an answer, because you always got to, in the back of your mind, you got to think, how is this going to look to a jury? All these depositions, every deposition you defend or take, how is this going to look in front of a jury? How is this going to sound? How are my questions going to sound? How are the word choices I use? Like Tony's saying, how do I sum it up to make it easy and bite-sized for the jury to consume? Always think that way, and that'll help you ask more crisp, concise, not big words, just really, just so that the common person can understand what you're saying. All right. So let's talk about the length of depositions, Rachel, and I know that I feel like the law just changed, but I'm realizing it's it's
been a while.
It's been a while.
It does feel like it
it's
just happened though.
I know it does feel like it just happened, but anyway, Rachel, you want to tell us a little bit about this?
Sure. So CCP 2025.290 is the code section that talks about the length of time for depositions. So most depositions are limited to 7 hours, but there are some pretty big exceptions. So an expert deposition and a PMK, person most knowledgeable depositions, those do not fall within the 7-hour requirement. And so what ends up happening is if you think a deposition is going to go longer than 7 hours, you kind of got to keep track of the actual time of testimony. And you can do that a couple of ways. You can ask the court reporter to keep track of the start and stop times. So if there's a break for lunch, if there's a break for, just for any reason, that time during the break does not count towards the 7 hours. And sometimes it gets down to the wire where you have, 5 or 6 minutes left and, you kind of have to wrap it up. But if there's going to be a deposition where, you need more than 7 hours, say there's a medical negligence case with 6 surgeries, and there's just no way you can cover that doctor's deposition in 7 hours. And it might take 2 or 3 days. You can either, one, get a stipulation between the parties to agree that we're just not going to follow that 7-hour rule, and we'll take whatever time we need to take. Because the bottom line is, if you go to the judge and present your case to the judge and say in a motion saying, there's just no way, we need more time, they will always give you more time if there's any good reason to have more time for 7 hours. I mean, I think that rule was pretty much put in effect, so there would be no harassment of witnesses unnecessarily. But if your case and the facts justify it, then I've had depositions go for a couple of days, but we usually stipulate to that. But expert depositions and PMK depositions, those are the big ones that don't fall into that category. Any thoughts on that, Dan?
No, I mean, this really was put forward, I think, by the plaintiff's bar, because you defense attorneys were just taking forever with our plaintiffs, And
it's all those I don't knows, Dan.
Yeah. No, but I mean, look, you should be able to get a depo done in 7 hours, but again, you never know. I mean, truly, it's but I really rarely see it becoming an issue. Frankly, I rarely see us, defense attorneys needing more than 7 hours with plaintiffs, and we have some very complex, serious injury cases, and they can usually get it done. I haven't seen it be too big of an issue. Have you guys?
No,
I've had it happen once or twice, maybe, but not often.
No. And usually I like to ask almost before every deposition, how long do you think this is going to take? Especially if I'm representing a doctor, say for a subsequent treating provider deposition, to take a chunk of time out of a doctor's day away from their patients. They want to know, is this going to be 1 hour, 4 hours, all day? And then, there's also the issue of making sure they get paid in advance. And so I try and get a sense before the deposition of how long it's going to be. I think the witnesses appreciate that, knowing it going in. And if I think they're going to be there all day, I let them know, you're probably going to be here all day. And even if you're not going to be here all day, just don't plan anything else for the day, because it's draining for most witnesses to sit through a deposition. I mean, the attorneys, they do it every day. It's not such a big deal, but for somebody who's sitting there under the gun answering questions for 4 hours straight, I usually tell them, don't bother going back to work that day.
Yeah.
And So it's good to have a sense before you go in of what the timing is going to be. And most people will tell you, if you ask your adversary, is it going to be 1 or 2 hours or all day or 2 days? Most people can give you a good estimate.
And when it does go long, there are usually, if it's going long, there's two things that play into that. One, it might be an inexperienced attorney who's not really sure about the subject matter or how to ask the questions. But more often than not, it's the witness who either they're deliberately being evasive, or sometimes I've had where you have a witness who doesn't speak English, and then you have to have a translator, which can sometimes take you well into close to your 7-hour time limit. But that's not very, very common.
Yeah, and also it just comes down to just working it out. I mean, the amount of time you're going to spend on the motion and opposing the motion, it's like you're probably 5 hours. Just give them the extra hour or 2 hours to do the depo. Is the amount of time you're going to do the motion work and cost your client money, frankly, is not worth it.
Absolutely.
All right. So Rachel, tell us about these things you guys file called summary judgment motions.
Well, I always try to get the plaintiff's deposition before filing a motion for summary judgment. If the 1 or 2 times that I have not done that, you can almost guarantee that opposition to the summary judgment motion is going to say, well, how do they know there's no issues for a jury to decide? We haven't even taken the plaintiff's deposition yet. So always, if you're thinking as a defense attorney, this is a good case for summary judgment motion, take the plaintiff's deposition, file a motion to compel the deposition if you have to get it done so that you're not backed up against a time crunch to get your summary judgment motion filed. But a couple of issues to be aware of when you're taking a deposition and thinking about summary judgment. So the first one is flushing out issues related to statute of limitations. So there may be some facts that you need to flush out in order to confirm whether the plaintiff filed her case within the statute of limitations. So if a case like I do medical malpractice defense, in my case, a lot of times the statute of limitations, there may be a plaintiff who has only 1 year from the date of the discovery of the negligence to file the case. And it's important to know what day qualifies as that date of discovery. So if a plaintiff had a suspicion of the alleged negligence earlier than she alleges, you need to ask the plaintiff when she had a suspicion of the alleged negligence. And the only way to get that information is actually asking the plaintiff, because that is the triggering date for the statute of limitations. There may be records you can use to get that information, but I have had plaintiffs testify that they knew of the alleged negligence way earlier than their complaint sets out, and there's my statute of limitations argument, and the case is basically over. So the second way is you want to confirm any triable issues of fact, obviously, and get out confirming whatever claims they have, whatever facts they have to back that up, you need to work that out and confirm it at their deposition. So for an example, a plaintiff claims she can no longer work due to a knee injury as a result of a negligent surgery. So you may be able to ask whether she was working before the incident, and you may have information she was out on disability prior to her knee surgery, and therefore there may be no loss of earnings related to the alleged negligence. So you can confirm all those facts and ask her outright at a deposition. Also, you can confirm whether the deponent's recollection matches up with records, and you may have inconsistencies there that you want to get out at a deposition. Identify additional relevant records. Say the plaintiff's discovery only talks about her primary care provider, but they're specialists, or what pharmacy records or employment records or any records that you may need to help either prove your case or defend the case. This is your chance to actually ask directly from the plaintiff or from whatever witness you're deposing, what is it you need, and then you can subpoena those records. And really, like Dan said, the key is to limit the issues for trial. And this is your one chance to do it. So, just think about what information you need to make out your case or defend it, and just narrow the issues for trial by asking those specific questions.
Yeah, and I'll just, from the plaintiff's perspective, you want to look at 437CH. So CCP 437C is basically the code section that deals with MSJs, but then section H kind of gives us as the plaintiffs, once you see all the affidavits, all the declarations, the separate statement of facts that the defense attorney has submitted to say there are no triable issues of fact, you go through those and you say, well, hold on, Judge, we still have to take, we just found out about these witnesses that worked at the corporation or did X, Y, and Z, or this other eyewitness, and we need to take their depositions, we need to, or get declarations from them. The judge can then, under that code section, deny the MSJ or delay it to permit us to conduct discovery, so say that there is a triable issue of each of those facts, and then therefore help us defeat the MSJ. So as a plaintiff attorney, you want to go through in detail to make sure that you have everything you need to oppose it. You ever deal with that? You guys ever deal with plaintiffs?
I don't, only because I do medical negligence. So mine are mostly supported by expert declarations. And my purpose of taking the plaintiff's deposition is to make sure that there are no triable issues of fact that come up sufficient to defeat whatever it is my experts' opinions are. And
right.
So, it doesn't really have so much to do with extraneous witnesses as opposed to the plaintiff and my expert.
And I do a lot of, most of my cases are personal injury. And so plaintiff's depo was critical. I would not even consider a motion for summary judgment without the plaintiff's deposition. I'll also say that might be slightly different with Rachel's types of cases, but particularly in personal injury cases, judges are not crazy about ruling in your favor on motion for summary judgment on issues where there are personal injury issues. I mean, it's done, it can be done, but it's not as common possibly as when you have, experts, and expert declarations that really just, that's truly outside of the factual aspect, and a judge can rule on those. So they're harder to get in some types of cases to prevail on a motion for summary judgment, but without a plaintiff's deposition, it's almost, at least for personal injury cases, it's almost impossible.
Yeah, you see them a lot in the personal injury side, where it deals with premises liability, like a trivial defect, for example, or there's just absolutely no evidence of any notice at all, or it's against a government entity. You see them a lot in employment cases, and I think that's probably where you more will use the 437CH to try to flush out more witnesses who can establish the pretext or the underlying reason for discrimination, or whatever the reason is behind some kind of termination, to try to beat an MSJ there. That's where I would use it.
I would also point, sorry, go ahead, Rachel.
I was just going to say the plaintiff's deposition are also really helpful, not just to knock out the whole case with a motion for summary judgment, but a motion for summary adjudication just on separate causes of action. So if I've got, a punitive damages claim or lack of informed consent, I can use the testimony of the plaintiff to say, well, she testified that the doctor did give her informed consent. So that becomes really difficult to overcome in an MSJ. Or if you're looking at, heightened damages, punitive damages, well, where is the malice and reckless behavior, that's not reflected in the records of the plaintiff's testimony, and you get that backed with an expert. You really need, those things can be knocked out, and then the value of the case goes way down, if you can knock out critical causes of action and kind of just simplify the case.
I'd also point out that definitely, if you're considering an MSJ, you also want to be very careful about covering the entire scope of whatever your issues are. If you let a witness answer, I don't know, to a question of fact that's important to your case, then you won't get your summary judgment or summary adjudication because you didn't really finish closing the circle, so to speak, on whatever the issue might be.
Plaintiffs can do MSAs too, guys. So don't forget that. You know, if there's a course and scope issue or something like that, you can we can bring those as well to get rid of some affirmative defenses. So it can work both ways.
Don't give anybody any ideas, Dan.
Hey, come on, you guys. I'm outnumbered here. So
That seems to be the trend these days. Actually, it's a little scary for us defense attorneys with the emotions to knock out affirmative defenses. So
it's about time.
That seems to be a big trend going on these days.
Offense is the best defense, you know. All right, so let's move on to talking about trial. So a lot of this is the world you're going to live in let me just give a quick caveat here. As a plaintiff attorney, you're going to see me put up a ton of words on a PowerPoint, breaking down statutes. I never, ever would do that at trial. My slides are like maybe 1 or 2 words, photos, timelines, just very, graphical, just easy for the jury to understand. So this is not how I do my PowerPoints at trial. I just want to give that disclaimer. Don't use this as an example, but what we're going to do is going to break down these statutes for you guys to show you how it actually works logistically at trial. And we're going to show you some examples. So CCP 2025.620 is really the post-deposition procedure. And that's what we're going to outline of how you use the deposition at trial. And then CCP 2025.340M is the use of video and audio deposition. So I'm a big proponent that if it's worth taking the deposition of a witness, it's worth videoing it. Because again, we're always looking to do it at trial. I think a video of a witness is so much more impactful than just reading the transcript to the jury from the pages. And nowadays with Zoom, and I know a lot of attorneys out there who are doing their own recording. You just have to read a certification on the record. But you should look into that if cost is an issue on a case. If you're taking the deposition over Zoom, I think there's a way that you can actually record it yourself if you just read a certification and then play the video at trial. Because videos at trial have such a bigger impact because as you'll see, you can play it in your opening statement, you can play it in your case in chief, you can play it to impeach the witness. And then when you see the witness squirming and the way they're acting and all of that, the jury actually sees that as opposed to the dry aspect of reading it from a transcript. So these are the 2 code sections we're going to go through and show you how it all works. So first, this is just the first paragraph of 2025.620, basically just saying you can use depositions against any party who was present and who had due notice of the deposition. So in all of our notices, standard notice, everyone on here knows how to do a notice. If not, we're happy to send you samples. But we always put in here that the plaintiff reserves the right to use the videotape deposition at trial because you have to give this notice. As you'll see, the code sections require you to put the other side on notice that you're going to use the video at trial. If you don't put this language in your notice, then the judge could say, sorry, you didn't put them on notice that you were going to use this video at trial, so therefore the video is out. The best you can do is read the transcript. So always have this in. Again, I'm happy to send samples of all this stuff. And then the next thing is that in order to play depositions, it has to be the questions and the answers have to be admissible under the rules of evidence. So if you think about this conceptually, this is what we talked about in part 1. This is why certain objections are not waived at trial. And this is why you don't need to make a hearsay objection, for example, in a deposition, because no matter what, you have to establish either a hearsay exception if you're going to ask the question at a deposition. So you don't waive it because the judge will rule on the question whether it is admissible under the rules of evidence. This is why all objections are not waived except for questions as to the form of the question at a deposition. So this is conceptually how this all plays out, because ultimately the judge is going to rule whether it's admissible under the evidence code under 2025.620. So also under this code section M 2025.340, it's that you have to send written notice. So the way this works is you get all your deposition transcripts, you're preparing for trial, and you want to play some parts either in your opening or your case in chief. So you have to give the other side notice. So in my office, we try to do, 2 weeks before trial if we can, or as early as possible. And we put it all together in a Excel spreadsheet. So I'll show you how it looks. So basically, here's the chart. You have to send a notice of intent to use portions of videotape deposition. This is a trial we had about a month and a half ago. We want to play doctor testimony. So in lieu of calling a treating doctor live, we wanted to just play his deposition testimony, take out all the stuff that was unnecessary, not even have him live on the stand, just do a direct on the video. And so we had to send this intent to the other side. And then we also wanted to file a chart. So what we did is we created an Excel spreadsheet that basically looks like this. So on one column, you have plaintiff's designations. So page 9, line 5 to 10.5. Those are just the different clips that we want to play. And then we'll have a video person put it all together. We then create a column for defendant's objections. So the defense has an opportunity to review each passage. Like I'll send it to Tony, and then Tony will say, okay, well, we think that 14(6) through 24 is objection vague. We then create, again, this is just an Excel sheet that we created. Judges actually really like it. It makes it super easy for them, and just so that they can just look at it and say, okay, here's the objection, here's the argument, and then we have the argument here. Then we also counter designate, which the defense is also entitled to do, or either side, whoever's the initial proponent of the designation. And then we object, and then on one column, the court's ruling. So how this plays in is that we have a binder prepared for the witnesses. You have this first, then you have the transcript, and then it's tabbed or highlighted for the judge. The judge then just reads it in chambers, usually the night before trial starts or at some point at a lunch break. And then they, on the column of the judge ruling, they'll just do, oftentimes they just do an O or an S, whether for overruled or sustained on the objection. And then once that's done, then you have what you're allowed to show the jury as a video at trial. Again, this makes it really easy for the judge, makes it really easy for the defense, because if you're going to trial, you want to make everything as easy as possible for the judge, because the last thing you want to do is waste the jury's time or the judge's time. And so you want to just be quickly up there. You don't want to be scrambling through your papers or reading your transcripts. You just want to say, here, we're locked and loaded. We got this done. You have someone go back and edit out all the sustained objections. And then boom, you got your video. You want to keep them as short as you can. And so, yeah, just makes it easy. Tony, any comments on this? Or Rachel?
I would say, yeah, I would just remind people that now that COVID has become such a intrusion on how we do things in court, this is even more critical, because it was more likely than not, it makes more sense to bring a witness in. You get live reaction with them, and they can connect with the jury. At least that's often what the other side would argue. But now that's not always an option. And so it makes much more sense to prepare something like Dan is explaining, because it comes in much more handy now than it probably used to.
So, and another point on that is so in this last trial we did, we didn't call a single doctor live. We didn't even play. I've had experts testify live on Zoom. Like I had an expert who was on vacation with his family in Ireland, and I was like, I can't move this trial again. He's like, all right, well, I guess we just set up in the hotel room, came in, it was great. And so we did that. But now, I mean, I'm oftentimes noticing, our experts or our treating doctors' depositions, and then just videoing them and do my direct examination. And then the defense may do their cross, and then boom, it's done. And then you just shorten it. You just take it, and then you can edit it. You can just make it, to just the bite size of all the information the jury needs, 20 minutes. And nowadays, like Tony's saying, we're all accustomed to Zoom. Jurors are used to looking at people all day on a screen. They don't care. Like, I don't think having the live witness there has the big effect. Frankly, giving away the secrets here, Tony, but I think that having the doctors come live almost gives off the appearance that they're a courtroom doctor. And right. These other doctors who are testifying by Zoom, they're just busy because they're treating patients, they're helping patients. So, I know this is kind of PI heavy advice, but when you're dealing with kind of, not professional witnesses, it's effective, and the juries are okay with it. And honestly, it saves everyone a lot of money. It saves, you know, both sides money, saves the litigants money when you can do it this way. So think about it. And I think the downside is not nearly what it used to be, as Tony said. Okay, so just generally speaking, just breaking down this code section, 2025.620A basically is that, you know, you can use a deposition of a party at any time. You can use a deposition of a non-party witness, you know, to impeach. So the way that would look is you have a non-party on the stand. You say, Your Honor, I would like to now read from page 10, line 16 through 11, line 6 from the deposition. So then if you don't have it videoed, you would then give it, the other side would have a chance to look at it. The other side says, well, Your Honor, I'd like to object as to, you know, whatever the basis for the objection is. The judge will rule on it on the spot, and then you would read, if the judge says, go ahead, counsel, you then read from it. Or the same thing with the video. The opposing counsel reads that portion, says, Your Honor, I'd like to object, or no, it's fine to go ahead and play it or read it, and then they'll just play it. So that's simple. And you don't have to do anything else. You just play it, and then you move on to your next question. You don't have to, I would never, frankly, say to the witness I just impeached, like, let's give them a chance to explain themselves. You just move on. You let it sit there for the jury. You take a long pause so it has the effect you want, and then move on to another topic. How do you typically handle impeachment, Tony or Rachel?
You go first, Rachel.
No, I don't usually see like a deposition used for impeachment, but you know, we mostly have live witnesses, so that maybe is the big difference.
Yeah,
in medical malpractice, we are still trying to get our doctors in or on Zoom. But yeah, I mean, if there's some good testimony in a deposition that you can use to impeach a witness, then I mean, that looks great. If you know, that's kind of the whole point of using you know, depositions at trial, I think so.
Yeah, I agree. And so there, I use it when I can. And I guess there's two ways to kind of think about this, depending on which side of the V you're on that day. But when I'm taking a deposition, if I get testimony from the witness that I know is going to be great impeachable, you know, testimony, I stop right there. I mean, at least for that issue, I don't ask for clarification. I don't challenge them. You know, if they said they got hit by a car, but they, you know, but they don't remember, you know, that it happened, odd as that might be.
Yeah.
Great. You know, I wouldn't even go any further than that. So from that perspective, you get great testimony, you know, you can use, let it go. Don't challenge them. Don't try to explore it, because you might end up getting an explanation that negates what you thought you had. On the other side of that, if my witness does that, if I, you know, am defending a witness and I can see that he's just given impeachable testimony that can be used, I will come back, you know, after a break, I might ask to, you know, to clarify, or I might just, when it's my turn, you know, to redirect, I might ask him a couple of questions that help explain why he or she said what they said, which you can then use at trial. If that testimony had been tried to use for impeachment, you can then use the remainder of what you know, how you redirected that testimony to save that issue.
Yeah, I agree with you, Tony. I mean, I think it's kind of a rookie mistake when you get information that you think you can use to impeach at trial, to just keep going. And it's really important to know when to stop, because a lot of times you'll think, wow, I'm on a roll here, I'm just going to keep at it. And, you know, might give the witness a chance to backtrack. So you got to watch out for that. Right.
And you also don't, if that person's counsel didn't pick up on it, that's even better. So just let it go. Yeah.
Right. Yeah. And when, like you said, if your witness says something that you think is problematic, I will usually take a break at that point. You know, and everybody kind of knows, oh yeah, we're taking a break. There's an issue. And I will, you know, talk to the witness and say, is this really what you meant to say? And they'll be, oh no, that's not what I meant. I'm like, well, now is a good time to go back and clarify, clarify it. And always the plaintiff's attorney will say, well, clearly the witness was coached on the break, but if you got to clean something up, I think it's better to do it on the spot. And so you don't forget, and it's just, it's all in one spot.
Or you can object and have
a lot of objecting.
Well, you object and
Right.
kind of have a speaking objection.
Under the table anymore. So all you can do is make a lot of speaking objections. If I'm making a lot of speaking objections, there's something that you really need to focus
Objection.
on.
She
Right.
forgot about the car crash she had 4 years ago. It's
Right.
Objection. Oh yes, I forgot. Yeah, the car crash I had 4 years ago.
Right.
Yeah. Help your witness out if you can.
Yeah. All right. So here's just the language. Again, this is the most often times you're going to see a deposition read at trial or played at trial. The next two things under 2025.620B is for any purpose, and this is an important one that we'll go over, and also an expert witness or treating physician. So let's break that down. So under 2025.620B, an adverse party may use for any purpose. A depo who at the time the taken was an officer, director, managing agent, employee agent, or designee, which is basically the PMK of a party. It is not ground for objection that the deponent is available. So this is I use this all the time to play in my opening statement the most damaging testimony from the defense employees, the defendant themselves, or a treating doctor or expert witness. So the way I use it, and I argue to the judge, I said, look, the code clearly says an adverse party may use for any purpose. And the code's doesn't say any purpose after opening statement or any purpose only in your case in chief. It says any purpose. So I've never found any case law that includes opening statement. I've never found anything that says it doesn't. It's really going to be judge specific whether they're going to let you play depo testimony in trial. I'd say about, in my experience, probably 70% of the judges allow me to do it based on this code section. But then I have, the 30% who say, well, that's not in evidence yet, so you can't play it in opening. I'd argue that opening statement is all about what the evidence is going to show. We know this is going to come in based on your rulings that you already ruled on the video testimony, and that it's all going to, pass the evidence code under your rulings. So it should come in. And I think it should 100% come in based on this code section. But if you're doing an opening statement, I would put, the 30-minute sound bites in there for your best stuff. And one is if you have good stuff from the defense experts or your treating doctors who are going to talk about how bad it is for your client or whatever type of case you have, you want to show the bad witnesses from the other side or the good ones for your side, just lay it out. It earns you credibility in your opening statement. So here's an example of what we did. Last year we had a case where my client was an electrician. He was working at this strip mall in somewhere Pomona area, and he's climbing up the hatch. You'll see here on it's my left, but here it just basically he climbed up and it just fell on him and really messed up his back. And there was a spring broken. So the hatches are supposed to look like here. A safety mechanism is the hatches are supposed to be spring loaded so they stop, so that doesn't happen where they fall onto people. So my client was pretty badly injured, had to have multiple spinal surgeries, and the issue is that the owners of the property, they knew that the hatch was broken for like years before, and they had people, the roofer had come out saying, hey, this is broken, you got to get it fixed, it's dangerous, it doesn't meet OSHA. They just ignored it, and then sure enough, it was like a ticking time bomb. My guy, unfortunately, is the one who got hurt by it. And then they denied that they knew that it was broken. So here it was the defense expert. And with this expert, there was a lot of stuff the defense didn't give him, information that he needed. So here was something that we played in opening statement.
Okay. If a roofing vendor had told Athena that the roof hatch was dangerous to open and close 2 years before our incident, should Athena have repaired the roof hatch?
If that actually took place, then I would say yes, there should have been proactive action.
Okay, but my hypothetical is, if Athena was put on notice that the ladder was 2 feet short and did not meet OSHA standards, at that point, whose responsibility is it to fix the ladder?
I would say that it's the responsibility of the property owners or managers to fix the problem.
And if they failed to fix it?
Then they suffer the consequence, I guess.
So obviously that's the sound bite I was looking for, like Tony was talking about. And I followed all those steps that we've been going over. Did the proper designation, proper notice, did all the spreadsheets, had the judge rule on it. And here I had this expert witness who was never told by the attorneys who retained him anything about what the property owner or property manager has done. That's who he was really hired by to represent, was a property manager, property owner. He's a safety engineer. And he was just basically saying it was all my guy's fault because he carried a tool belt up there. And he should have known better than carrying his tool belt that bumped the latch. But he had no information about this. So then I got him to say all this, and they should suffer the consequences. Well, yeah, the consequences is, a judgment against them. So these are kind of the things that the sound bites we're talking about. Once you get it from an expert, I didn't go show him anything. I didn't show him all the emails where they were on notice for years. I held that in, like Tony and Rachel were talking about. You hold that stuff back because he just gave me exactly. I agreed with him. I used him as my witness. I played it in my case in chief. I played in my opening statement, and I said, look, this is what their person is saying. The rules are, folks, that if they knew about it, they should fix it. If they don't, they suffer the consequences. And then so it just makes it that much more powerful, because it's not me, the plaintiff attorney, asking for money for what happened to my client saying it. It's the defense expert saying it from his own words. So it just earns you credibility, I think, by being able to do this in opening. But the reason why we went through all this procedural stuff is because you have to do all that stuff, or else I'd never have this opportunity to do it at trial.
So Dan, I am kind of curious, did your judge say whether that would be cumulative testimony for him to testify at opening and then later in your case in chief?
So at opening, no, because it's not evidence. This is where, but that's a really good question, because here's where you could run into some issues, and you people do, a lot of attorneys do, and I have before too, is that if I wanted to play the best parts of his testimony in my case in chief before the expert witness comes and testifies, the judges could say, and they often do, that is cumulative, and you can't then ask the defense expert those questions when you cross-examine him. So you got to make a decision. Do I want to get out in front of it, have the jury see it before he testifies, and then forego my ability to cross him on that? And it's just, it really is, this is where it's an art, not a science, what we do. It's just kind of a judgment call. I mean, I personally think it's pretty powerful if you show them the video in your case in chief. And then a lot of times what happens, frankly, is that the witness is on the stand, the other opposing party asks them a bunch of questions. You can ask non-cumulative questions to make the same point in your cross-examination. Is that kind of what you were asking?
Yeah. I was kind of wondering how you got that expert out in front of the jury more than one time. So that's a good strategy.
Yeah. Yeah. So Tony, anything on that?
I don't think so. I mean, I haven't quite done it that way. I usually will wait until case in chief. But yeah, no, it's a good plaintiff strategy for sure.
I've just been warned, you're only going to have your witness up in front of the jury one time, so you better choose the timing wisely. So
yeah, oh yeah, no,
about putting that up in front of it, an opening.
If it's but again, opening's not evidence though. So on the flip side, judges what they could do is, if you play video or if you show any evidence in opening, technically what they could do, they often don't do it, but what they technically could do is if you show something in opening that never makes it into evidence, they could declare a mistrial because you showed something that was never ever in evidence. And also, I mean, also you should be punished by the other side or the jury to say, look, opening statement, you better be damn sure you're getting it into evidence before you show anything. That's how it should. I mean, frankly, you should. I mean, you shouldn't show anything that unless you're 1,000% sure that it's going to get into evidence, because you risk your credibility. It's against the law. Frankly, it's improper. It should be grounds for mistrial. And so, yeah, there's just a lot of reasons not to do it. That's why, again, you got to give the judge and have them rule for sure. You're allowing me to get this in before you do it. That's why you got to, cross every T, dot every I.
Great to get that spreadsheet and those rulings before you use it.
Yeah, you better get them. You absolutely better get those rulings.
For sure. From the defense position, that actually might, as a strategy, it might be a little easier if you're going to be using the plaintiff's testimony. I mean, you're pretty sure that'll get in. That shouldn't be an issue, depending on what you want to play. But it's much harder. I mean, it's much more dicey if it's an expert than if you're a defense attorney and you want to play a piece of the plaintiff's deposition. I would think that we wouldn't have much issue with that being evidence at all.
Yeah, I mean, the only time I usually use, if I'm only going to show a treater, for example, a non-retained treating expert in my case in chief and not call them live, I'll play that. Again, it's got to be bite-sized. You don't want to sit there and bore the jury. Even that clip was a little long, I'd say, for opening, but, maybe I would show a non-retained just a real quick to talk about, they're going to, be in pain the rest of their lives. Just something like that real quick. And then I'd play the 30-minute whole thing in video. But a retained expert or someone like that I'm going to call live, I probably wouldn't necessarily do that. But defense experts, I do all the time. Defense witnesses, and if an employment case, employees, the supervisor, HR person, I'll 100% play those sound bites for sure.
Makes sense.
And then the last part of 2025.620 is just, when can you play non-party or read or play non-party witnesses under which circumstances? And it's really unavailable, or they reside 150 miles from the place of trial. Unavailability, it's always, it's the judge's call. Wouldn't you guys say? I mean, in terms of what is the definition of unavailable? Tony, how have you run into that?
That is exactly what happened. The judge will say, they'll ask you, is this person at work? Are they, have they left the country? Have they left this, it really depends on what the issue is. I mean, it's safer to try to get them there than to have those fights with the judge, but it really depends.
Well, recently also with COVID, there's been witnesses at the last minute who have had COVID. You might have an expert that you've paid a ton of money to, and come time to testify, and they've got COVID. So, they might be able to testify, using their deposition if they're sick, unless you can wait for them to recover. But that's another unavailable.
I guess that's another example of how
come up a few times.
Yeah, and another example of how COVID is now intruded into trials in a real meaningful way. Because you're right, that right there, I think any judge will be okay. That's sufficient, right?
Yeah. All right. Well, that's about all I got for the trial stuff. Do we have any questions here, Tony? I guess we answered everything, huh?
Yeah, I think so. I didn't see any questions in chat, unless I'm looking in the wrong place. I didn't see any.
Yeah, well, that was a pretty thorough overview of depositions. If anybody has any questions, feel free to reach out to any one of us. If you need examples for notices or objections to depositions, or anything related to depositions, contact any of us. We're happy to answer any questions.
And I would just remind everyone that, this is a very deep well of information. We've still just kind of scratched the surface. We haven't talked about, we mentioned PMKs and expert depositions, but those happen in slightly different ways. And there are certain questions that have to be asked and answered to make those effective. So that might be something we do in the future. We'll have to see. Anything from you, Dan, before I sign off?
No, yeah. Look, like Rachel said, anything you guys need, feel free to email me. I'm always happy to share. We have lots of samples and forms and anything you guys need. Really appreciate it.
Yeah, the
Great
last
holiday.
final thing I would just like to end on is to remind everybody to keep it civil. You know,
Yeah.
Yes, yes.
even though we get into heated debates at depositions, it's always things go a lot smoother when you can keep it civil with your adversary and your witness at deposition. So,
And I appreciate that you said that, Rachel, because that's really important. All of us should kind of remember that. Don't give us lawyers a bad name. And so thank you, everybody. Hope you have a great holiday. And we appreciate you giving us your attention. Thank you.
thank you.
All right, everybody.